Any mention?
Lord, I beg to mention, my Lord, in item 9, that election of Doloy, my Lord, of Ilaka Rambai. My Lord, I am the Dorbar, my Lord, of Ilaka Rambai. My Lord, I wish to file my
No, let's talk about is an orders or hearing.
my Lord, I've just filed my application for impleadment, my Lord.
It's all right. Or you want to take application and impleadment today? Okay. It's what foreign-in-law. Who's appearing for the petitioner?
Mr. Sepan, my Lord.
Where is he? Have you served copy?
Yes, my Lord. Yes, yeah.
Where? Okay, bring the miss case on board. Where is Mr. Sinkan? Have you received a copy of the impleading petition? Okay. Bring it together with the meat file. Yes.
May I please, Your Lordship, I beg to make a mention of party of the hearing list, item number 22. 22.
20?
22 and 24.
Why?
I have some personal difficulties today. If this matter may be taken up next week, Your Lordship.
You're for the respondent number?
For the respondent number, state respondent.
Yes. Yes. Your objection?
Item number 24, I am for the petitioner.
Yeah, objection.
1 week, Lordship.
No 1 week business. You adjourn it?
Here, Lordship, what happened? I have
There's some urgency?
Yes, Lordship. I have been disengaged. My last.
Then no adjournment.
1 week since my son is asking for 1 week, okay. But
Okay, 1 week.
And
Team
item number
Mr. Abraham. And 22?
24.
Who's for the petitioner? You have no objection? 2 weeks, yes.
22. Ali Abdul.
I beg to mention item 21, my Lord, for hearing. This matter can be taken up after 2 weeks.
Who's the other side?
Mr. Socialize.
What's the matter about?
Look, this is regularization, artificial gaps.
2 weeks, yes.
People.
May I please, Your Lordship, I beg to mention item number 30.
30?
Yes, Lordship. That this matter must become after 1
Who's
week.
the other side? You're for the
Respondent number 4.
30?
But there are 3 respondents.
2 weeks, yes. Yes.
Please, Your Lordship, I beg to mention item number 12, Your Lordship. 12.
This matter is a long pending matter. It's connected to which matter, this one? Along with 59. What's the problem?
Lordship, Mr. Paul is having some personal difficulty, Your Lordship.
He?
Having some personal difficulty, Your Lordship.
No more adjournments, huh? We'll have it after 1 week, yes. Yes.
13 connected, Your Lordship.
30,
Similarly
30.
for item 18, Your Lordship.
Number?
18.
Where's Mr. Das? Have you taken consent?
Yes, Your Lordship.
This matter is some urgency in this matter, correct?
Yes, Your Lordship,
Then?
but they are asking. The last chance will be given.
No question of last chance, it's a question of convening of parties. And we'll hear it now, no problem.
If they are ready, then Sir is here.
You ready today?
Lordship.
This matter was, I think, heard at some point
Yes,
of time.
Lordship.
What was the matter about?
Written argument has been closed, Your Lordship.
Yeah?
Well, written argument for the RT has been closed, Your Lordship. To file written argument.
Let us hear what is the matter about. If I can recall.
Is that for Debt Recovery Tribunal Guwahati?
Yes. This is regarding the other civil suit is pending in some other place.
No, Your Lordship. Only in DRT, we filed the review before the DRT, it was dismissed.
This is regarding the written statement.
Written statement which is
Yes.
but they have the
1 week only. Yes. Due to the difficulty of the senior arguing counsel. Yes.
Please, Your Lordship, I beg to mention item number 31.
31.
no objection.
3 weeks, yes.
Thanks for apologies.
Lordship, I'd like to mention item number 32.
32. Yes, sir.
Lordship, pay for 4 weeks, Your Lordship.
4 weeks, sir. Yes.
May it please, Your Lordship, I beg to mention item number 35.
Number?
35. 35.
On behalf of Mr. Gautam.
Yes, Your Lordship.
No objection.
How long?
2 weeks time, Your Lordship.
2 weeks. Okay. 2 weeks. Yes.
Obliged.
Lordship, I beg to
One
make a
ending.
mention
Yeah.
for item 33, Lordship.
Number?
33.
23.
33.
Your Lordship, 32, 33 and 34 all connected matters, Your Lordship. These are the nectar matters.
Nectars.
Oh yes, let's go. After 4 weeks.
No obliged.
Yes. Unending, yes.
May it please, Your Lordship, I beg to mention item number 19, Your Lordship.
Metu Sangma.
Yes.
It was had quite a few
Trying
times.
butter?
That is a dismissal from service.
Why is it pending?
The conducting counsel is not keeping well.
It is at their instance, my lord. It was hard at some length, my lord, probably more than one occasion. Then subsequently, my lord, time was given to them to prepare
To
further.
prepare the case.
Is that, my lord, issue is confined to that thing. They are only raising a technical plea, saying that the repealed provision of law has been invoked in initiating and conducting departmental proceedings. That is what they say.
Who's your senior?
S. Kumar, Your Lordship.
Mr. S. Kumar. 2 weeks, yes. You tell Mr. S. Kumar, next time it comes, then you'll have to argue the matter. What's your name?
N. Kharsano, Your Lordship.
N.
Kharsano.
Harsad.
Kharsano.
Harsano. Yes. Yes.
May I please, I beg to mention item number 23. We pay for 2 weeks time.
Why? You're not? Don't say that. You argue it. What's this Garihana Masjid? Where's Mr. Changreso?
He's out of station, Your Lordship.
So he's seeking time also.
So join.
Join because the party is matter for 2 weeks. Yes, enough.
Main list, item number 1. Main list, item number 1.
My lord, the respondents were directed to file the affidavit, my lord, in this matter. So, my lord, we couldn't file.
Who are the respondents?
The corporation, my lord, MECL.
Yes, why have you not filed
My
affidavit?
lord, due to oversight, my lord, I didn't remember we were supposed to file, my lord. My apology. I require just 1 week time, my lord. We'll be filing course.
There's a 1 week's further time as paid by the council for the respondent corporations allowed for affidavit. Just on so and so.
Highly obliged, Lord.
Supplementary list, item number 1.
Please, Your Lordship.
Once we let the file come. Yes.
Your Lordship, there's a contempt application with regard to the violation of the judgment and order passed by this Honorable Court on 8/7/2022.
Yes. On?
8/7/2022 in WPC
What is
7.
the violation?
Your Lordship has passed an order, Your Lordship, with regard to the.
No, what was the operative part of the order?
Page 17, Your
Page?
Lordship. Annexure
Page?
1, page 17, operative portion is on page 17, paragraph 8.
Page 17, yes.
If I may read, Your Lordship.
Yes.
In this view of the matter, looking into the facts and circumstances of the case, and as per the submission of the learned counsel for respondent number 5, it is directed that the respondent number 3 shall ensure that the petitioner be allowed to avail the benefits of the scheme under the Mahatma Gandhi National Rural Employment Guarantee Act. The respondent number 5 shall allow the petitioners to work, and they are to disregard the earlier jobs card, ration card issued by the Mautiam village. It is further directed that respondent number 3 shall communicate the same to his counterpart at Ranikot CNRD blocks so that confusion no longer arises. The respondent number 5 is also directed to ensure the petitioner are not discriminated against in the manner or deprived of any benefits or occupation, Your Lordship.
What? They have not done anything?
No, Your Lordship.
Till when was the order passed?
8/7/2022.
Surat MS P. Biswa Karma. issue notice, steps to be taken within 3 days by receipt AD. Okay. This thereafter after 3 weeks.
Much obliged.
Item number 2.
Yes,
Lordship. Your Lordship, here the petitioner is the absolute owner of the lot. He possessed even the land pata,
absolute owner, what plot?
He's having the plot of land, Lordship. It is Asana. Now what happened, because he has been possessing this land for more than 5-7 years, but he has got the pata also. Now what happened, there's some private respondent, they come and some doing business in my land. So to that effect,
What kind of business in your land?
They are just coming and selling some kind of fees or something like a marketplace, using like a marketplace. On the basis that some person, the private respondent, have filed a case in the JCTC. But however, Your Lordship, there is no notice, nothing has been received till now. So we have approached the Deputy Commissioner, SP, and also the JCTC, requesting the department to stop those private respondents coming and doing the business in our land, but nothing has been doing, because even this private respondent, they're continually disturbing, they're not even allowing.
Where have you made GCC party?
Yes, Lordship, here only, Lordship.
Have you made Government Council party?
We make a party because they said.
So where in the cost title you made them a party?
It's not there, Your Lordship.
Just wait. Let them submit.
It's not a party, but in the representation, Lordship, it is there. But I think in the
The
representation.
civil dispute, you withdraw it, you file a civil suit, you seek proper injunction. The
Lordship,
court is not in a position to see whether in possession or not, or to go on the title deed.
I have enclosed the land document, Lordship.
Land of what you enclose the document before the court, before the civil court.
But these people, they are not claiming for the land. They're just coming.
So you
doing
stop
the
people
business.
from encroaching to your land. You file a suit, get an injunction. Court's not to advise you. You have not met this GHC party also. If you see some proceedings before them.
We'll withdraw and liberty may be given.
After hearing at some length, petitioner seeks to withdraw with liberty to file a flight to seek alternate remedy. Yes, that stands closed in this folder. Yes.
Item number 3.
Yes.
May I please, Your Lordship, I humbly plead let this matter pass over for tomorrow, Your Lordship.
You move it. What is there in this case?
I apologize, Lordship, but I don't have the brief.
You don't have the brief. Where's the senior?
Actually, he about to do
You give her the correspondence brief. You reset down there, you read the brief, and we'll have it after some time.
I have the free honor for this tomorrow.
No, you read it. If you have difficulty, court will help you. You read the brief after some time. End of the board. You read it. You sit down there and read the brief. Yes, next.
Main list, item number 2.
Yes. You tell her, you read the brief, you make notes, and then, okay? Yes. Yes, Mr. Kareem.
Lordship, respondent 1 year before he had to file the
Have you obtained status?
Lordship,
Have you obtained status of service on 8 and 9?
yes, Your Lordship, but Lordship, I'm praying for a week time, Your Lordship, to file affidavit of service, Your Lordship.
Okay. Mr. S. Kareem, prays and allowed 1 week's time to, for the time to obtain the status of service, respect response 8 and 9, and to file service affidavit.
Lordship, the
What about
status,
affidavit from 5 to 7?
status file, Your Lordship. 1 to 4 file.
1 to 4.
Affidavit file, Your Lordship.
Mr. Next, ND Shulai, Learned AAG, which also submits that the affidavit on behalf of respondent 1 to 4 has been filed. Just a matter after 2 weeks for service affidavit and for affidavit by other respondents. Yes.
Obla, Your Lordship.
Item number 3.
Yeah, please, Your Lordship. The affidavit is ready, but then Your Honor, Your Lordship, we have sent for signature. We haven't received it, as the CM also is on leave, so we will be filing. I pray for a week, Your Lordship.
Not filing.
We'll be filing in the course of the day.
Is further 1 week's time granted to the respondents to file affidavits thereafter and so on.
Item number 4.
Maybe one.
Please, Your Lordship.
Yes.
We pay another 2 weeks time for file the affidavit.
What about 428? You already filed.
Okay.
For some more time.
Not yet, they have not filed.
What's the matter about?
This is about land matter, land dispute, Your Honor.
MS N. Raji for 123 and E1 Yang 4834 and allowed?
It's S. Martin.
Huh? S. Martha, sorry. S. Martha and between two of you is S. Martha and 123 and E1 Yang 4834 and allowed. Further 2 weeks time to file affidavit.
5.
May I please, Your Lordship? Your Lordship, I'm for respondent 1 and 2. I'm praying for some more time, Your Lordship. I'm praying for some time, Your Lordship. For respondent 1 and 2, Your Lordship.
I'm trained for Petitioner.
2 weeks time for the time granted respond to file affidavit is thereafter and so on so.
Obliged. 6.
One second. MS, go ahead. Yes. Yes.
I have filed an application for variation and vacation of the interim order.
You have not filed your
I
reply.
have already filed, Your Lordship, yesterday.
You have received a copy?
Yes, my lord. My friend there has received a copy and I have received it via a soft copy. I have received it.
So shall we take it up now?
No,
Are you ready?
My lord, there is some urgency, my lord. My lord, this tender is regarding supply of dry ration to the.
Understood.
My lord, what happened? The previous contracts expired in the month of March, my lord, 31st March, and 3 months extension was given. That is also expiring in the month of June, my lord. Today we are on 27th, so 30th of June, my lord. So we are facing a situation that will be without grocery, my lord. Approximately 2,000.
So we'll hear it now.
No, Your Lordship, I am not prepared. Actually, the conducting counsel, he is not well. So let the matter be taken up next week, Your Lordship. Conducting counsel is from Silchar.
Some difficulty.
I am here only to assist him, Your Lordship. I am not well aware with the facts.
No, you can't have that. You can't have the forces going out without rations.
The interim order.
And who are you, MS Goyal? You are for the private respondent.
My lord, I am also,
the successful tenderer.
I am also.
My lord, that is the most crucial
no,
aspect, my lord. My lord, only the technical bits have been open till now, my lord. Three participants have been technically.
So why is the technical bit rejected of the petitioner?
Not rejected, my lord. They have
My
come
lord,
challenging
if I may just correct my friend, I'm sorry, I'm just interrupting. If I may just correct my friend, the technical bits are yet to be opened. Even the technical bits have been not open, and it's a premature petition.
Three have technically qualified, my lord. Now the financial bits are yet to be opened. In the meantime, the petitioner, my lord, had challenged the qualification of the respondent number 3 on certain technical grounds, saying that he should not have been qualified.
What was the technical ground?
My lord, the ground is that clause 6E of the tender says, my lord, the bidders will disclose all the existing contracts.
They had subsisting contract with the Assam Rifles.
Subsisting contracts.
Yes.
So that is the only, and the purpose of that, my lord, is whether, because they have to obtain a financial standing certificate from bank, that this person is competent or financially able to execute this much of work, my lord. So only to monitor that, my lord. And on that ground, they have approached this honorable court. Now the irony, my lord, is, lordship, if respondent number 3 is disqualified, my lord, then there remain only 2 technical bidders, my lord. The tender has to be cancelled, my lord.
Where has the counsel appeared from Silchar?
He is not well, Your Lordship.
Then should have put another standing counsel as a matter of urgency.
So next week he'll be there, Your Lordship.
But the interim order may not be continued.
No, Your Lordship.
We will vacate interim order then. Was it filed? Had 2 weeks elapsed since you filed the application for vacation?
My lord, no, but the interim order does not exist now, because on 20th June, when the matter was listed, there was no interim order passed that day. So there is no interim order existing as of now. They have to file a fresh petition if they want to. Only a clarification is required.
Last time I have prayed for the interim order be extended. So
It came up last week, this matter.
Yes, Your Lordship.
20 June.
20th June.
We have it tomorrow.
Your Lordship, he is not well, Your Lordship. He has to come. Let it come on Monday, Your Lordship.
Tomorrow you can engage some other counsel. It's as a matter is of urgency. This is matter tomorrow. As the first item supplementary list. Prepare.
I'm grateful.
You may continue, Your Lordship.
Yes.
There's no continuity.
We will see tomorrow. Not matter.
Item 7.
As it is not doing anything, does not open the technical bit.
Item 7.
Much.
Yes.
Lordship, I have filed my impediment.
You already filed it?
Yes, Your Lordship.
If you take that up first. Miss K, where the Miss Case? Yes.
Filed on the 23rd, 6th of 2023.
This is case number 95/2023, NWPC number 109 of 2023. This is an application filed for implement of the the Sobri Bari VEC, represented by its president under Salsila, Seen RD Block, Post Office Source Sobri Bari, SOBRI, Biar, West Kargil District, Meghalaya, and Shri Azizur Rahman, the Secretary of the Sobri Bari VEC, as respondents number 7 and 8 in the connected petition. So I've heard Ms. Lau, the constitutional petitioner, and also peruse the amendments made in the application. Stop the same not objected to by MS NG Shilla, the same advocate. That is the president and MS and Mr. Who is this? Shri Azur Rahman, secretaries also, I hereby impleaded as respondents number 7 and 8 in the connected petition. This case stands as posed out.
Lordship, at the meantime,
And waits in the main case, in with the order passed and so and so, registry to make corrections to the cause title. Stop. Petitioner to take steps to issue notice on the newly implemented respondents within 3 days. Yes.
amended petition in Lordship. I would like to file amended petition also.
For implement?
Yes, Lordship.
No, that will be added by registry. You take steps.
Okay, Lordship.
Yes. This after, you take service after 2 weeks. Only one thing, you've seen the last order. Has anything been done? You got any report instructions?
Lordship, I've received instructions, Lordship.
What does it say?
Lordship, that the bills of the materials and components of those projects which has been completed, Lordship, the bills were released along with other VECs to avoid unnecessary litigation.
No,
Lordship.
not that. See the last order, 19.5. That the inquiry was undertaken and the secretary of the VEC was not a party. He assaulted the petitioners for lodging this complaint.
I'm sorry, my lord. The last query made by this court was whether the amount was released or not, Lordship. I'll have to check.
Last order is 19.5.
Lordship.
That is, 9.5 order is different.
Lordship.
The 19.5 order is different. That Deputy Commissioner directed to look to the matters that no untoward incidents happen.
Lordship,
it seems criminal FIR has been filed also.
Lordship, the criminal petition has all been filed, Lordship.
Further instructions to follow from the government advocates are also for affidavit. Yes, accordingly.
Much obliged, Lordship.
Item number 8.
Yes. Have you filed it, Dr. Mazika?
But I'm praying for some more time.
Yes, 2 weeks further time granted. Well, it's corrected. The other 3 matters have been adjourned. So, interim orders there.
Interim order is there,
No.
along with all the connected matters.
Much.
Item number 9.
District Council is yet to file the affidavit. My lord, I have received a copy. My lord, we will be filing our objection to this.
You have no objection?
My lord, we will be filing our objection.
Why? Where's the implementing petition? Implementing petition in this case. This case, oh, yes. One second. 1 second, Mrs. Navi.
Status number 1. Yeah, status number 1.
See, but a challenge to the notification, Ms. Longbury, if you remember, because it's very cryptic and vague.
Correct.
That is why.
But then, my lord, the issue that is being raised in this writ petition is regarding the lenya, my lord, the religious rituals. So, as a Darbar, my lord, I'll be able to throw light on that, my lord. I will also, my lord, hand over a book, my lord, commentary on this ilaka, my lord, which should clarify the custom.
But now he has objections in treatment. Let him file
He
objection.
is seeking for election to this very Darbar, my lord. And Darbar consists of all the adults of.
Anyway, he's entitled. He will
Yes.
file case. Miss case number 96 of 2023. So this is an application. Miss case number 96/23 in WPC number 126. Stop. This is an application for intervention and treatment of the Darbar Ilaka Rambai Dorship as number 4 in the connected writ petition. Next by Mr. Piraman Nombi submits that the implement is necessary as the Darbar will be able to shed light on the customs and practices that are prevailing in the Rambai Ilaka. Next paragraph, Mr. Ensign, however, has praised that he may be allowed to file objections and implement petition. Praise allowed to list this matter after
2 weeks, my lord.
2 weeks for objection. Yes, list main case.
Main case, my lord.
Well, I'm yet to file affidavit.
Main case
In the
listed
meantime,
today
I'll
also.
file.
Yes. How much time? 2 weeks further time granted to the Respondents Council to file affidavit. Is the interim order?
My lord.
The interim order we shall continue till next day.
Obliged.
State.
State is not necessary.
Item number 10.
Your Lordship, item number 10 is connected to with item number 11. I'm praying for some more time to obtain instructions with regard to the release of money to the third supplier, Your Lordship.
See the last order.
Yes, Lordship.
Where's the order dated 2nd 5?
Lordship?
2nd of May was order dated 2nd of May.
Yes, Lordship.
Yes.
Lordship, I'm praying for
Yes.
some more further time to obtain instructions.
What details? If you made a submission 2nd of May, that is now sitting in, going to be sitting 2nd of July soon, next week.
In fact, Your Lordship, in this case, I have filed the affidavits. I have filed the affidavit yesterday. Bring on record the relevant contract paper of the contractor whose bill has been released, Your Lordship.
Bill has been?
Whose bill has been released, Your Lordship.
The third supplier.
Third supplier, Your Lordship. Exact same day. Exact same Lordship. The third supplier, Your Lordship. It's not before, Your Lordship.
Lordship, with
His
regard
contract,
to
his
that.
nature of contract, utilization certificate.
Regarding that further, right?
Yes, sir. Exactly same, Lordship. His bill has been released.
Where's the affidavit?
I filed yesterday, Your Lordship. Petition 279, Your Lordship. I'll dismiss evidence.
1 second. Button.
Petition 279, Your Lordship.
No. What is the total payment made?
1 crore, and only 50%, Your Lordship. 1 crore, 2,66,000, Your Lordship.
And the same circumstances
Same, Your Lordship.
where they were, the other petitions were you were engaged
Yes,
to
same.
supply for the.
Same quantity, that even that point also same, Your Lordship. You see also same, Your Lordship. Everything same, Your Lordship.
Those animals on the relief camp.
Yes, Your Lordship.
They were on the relief camp, the animals.
There's a stand, Your Lordship.
This Annexure C, page 10, is Dr. D. Roy, on which date did he give this certification? Which date?
No date. Even my UC certificate, no date, Your Lordship. And the quantity, exact quantity, Your Lordship.
That means you are Silkadishira, and the other one
And
is
Priyanshi,
Priyanshi.
Your Lordship. Priyanshi.
So in this Annexure D, page 11,
Yes, Your Lordship.
Gautam Enterprise paid 1 crore and this one 31 lakhs.
Yes, Your Lordship.
Very good. Yes, take down. Though the matter was fixed today for filing of affidavit by the state respondents to bring on record the payment made to other suppliers substituted, the same has not been forthcoming. Stop. MS Thungwa praised that she made also some more time. Next paragraph. However, Mr. Armajao has drawn attention to this court to an affidavit filed on 26/6/2023, wherein at Annexure D, page 11, a sanction order dated 27 March 2023 has been annexed, showing the factum of payment of an amount of rupees 1 crore 34 lakhs 39,437 to two suppliers. This is matter. When are you going to come up? This is matter for instruction for affidavit by the state respondents after 1 week.
Hurry up.
Otherwise, you're swimming in troubled waters. Yes.
Hearing item 14.
You ready?
We will be filing the list of events in the course of the
List
day.
of?
Events. We were supposed to file the list of events.
When were you supposed to file it? 27. This events? This is that decree, right?
My lord.
You want to join any? Where's Mr. Kurishi?
He's having some personal difficulties.
What personal difficulty is he having? It becomes very difficult to adjourn matters, because how many juniors does Mr. Kurishi have?
Two of us, sir.
Who come to the High Court? Only you come. What to do?
I've already filed the.
I know, Mr. Hatke, what to do?
If I'm not wrong, this is purely an intention, my lord.
I do not say that, but that is apparent. They don't want those who fight and run away live to fight another day. That is Mr. Kurishi's dictum. Huh? We'll discuss after 1 week. This is matter after 1 week, as Mr. M.F. Kurishi arguing counsel for the appellant, for the petitioner is not available today.
Highly obliged.
It's expected list of events as volunteered to be filed by the petitioner should be on board the next day.
Highly obliged.
15.
May I please, Your Lordship? My Lord, this is the bulk program matter. The state of files.
One second, before we take up the matter, where's Maham? You ready? Yes, take up the matter, this motion matter. Have you read the file? Is it very difficult? Not difficult at all, correct? See, you should try to build a confidence. Just because senior is not there, it's only for motion, it's not for any interim orders or anything. Yes.
This matter, Your Lordship, is regarding for the petitioner is the son of Shri Biral Prasad. He died, Your Honor, and he was posted as a senior store superintendent. And after that, Your Honor, while he was in service, so he died while he was in service, Your Honor. So our prayer is to appoint him on that.
So when did you apply for compassionate ground? When was the application made? Union, you are the union respondent. Yes. Anyway, continue. Yeah.
There is one letter also, Your Lordship, in.
Pull the mic closer. Yes.
There's one letter in Annexure 3, Your Lordship.
Annexure 3, okay.
Where they have said that that he can be appointed as in the father's post, Your Lordship. So.
Annexure 3 page?
45. Page 45, Annexure 3.
45.
Yes, sir.
Where's the union?
As the petitioner is dependent on the pension of the father, Your Lordship, so it considered to appoint in his vacant post, Your Lordship.
Yes.
On the permanent, regular basis.
Yes, take down. But Ms. Martina, this application has been filed by seeking appointment compassionate grounds under the relevant scheme of the respondents. Stop. Issue notice, returnable in 3 weeks. Ms. House present on behalf of the authorised Musica, it's present on behalf of the respondents. No further notice required. This is matter of 3 weeks for instruction of the affidavit.
But the maintainability may be.
Yes, whatever. Yes. See, why you should not. If it matters like this, why should you take time? If it's a very tricky matter, we understand. And you always have to brief. Does he keep the brief away from you?
No, you didn't get it.
He hides the brief in the chamber. He doesn't show it to the juniors.
No, Lordship, actually, we just forgot the file. We just forgot the files, Your Lordship, that's all.
So he doesn't let you sit when he talks to clients also?
No, he allows.
He allows.
Yes.
Then you should know what the case is about. You should have confidence, you should build your confidence, because that is an advocate has to have that inherent confidence. You understand? And you have to build it. No good teachers made, no good judge, no good. It's by practice. Remember that. Good. Yeah. You return and file back.
before my learned friend begins, may just point out one thing, Willits. This matter had been listed on the 7th of September 22. If Lordships will kindly have that order.
Yes.
Lordships had posed a question to the petitioner with regard to the status of the petitioner's society and their registration.
Yes.
So my learned friend had sought 2 weeks' time to obtain instructions.
Yes.
Now, without any further orders enabling him to file any affidavit, what they have done, they filed this affidavit on the 22nd of May 23.
Okay.
Can we have that affidavit?
No leave of the court.
Well, no leave. And something more interesting, it appears that the registration perhaps had lapsed. So in this intervening period from 7th of September 22, they undertook an exercise to get themselves re-registered.
From 7th of September 22.
7th September 22, Lordships had posed this question. They sought time to obtain instructions.
Yes.
And then they filed this affidavit on the 22nd of May 23. Kindly see para 2.
Yes.
So they say that the association was registered under the Meghalaya Societies Registration Act and it was an existent at the time of filing of the writ petition. And in as much as there is no validity period, which is incorrect, there is a validity period. However, the same, though not necessarily required to be renewed, the association was requested for renewal of the same. Accordingly, the certificate of registration was renewed. Wide renewal certificate dated 13/4/23, which is at page 4. So they renewed it with effect from the 13th of April 23. And this validity period is 3 years.
Yes, Mr. Yevin.
My lord, when we have filed this case,
you are still registered at that time.
It was all along, my lord, all along, right from the Guwahati.
No, that time when you filed it, were you a validly registered association?
My lord, the association was already a registered association, my lord.
Was registration valid at that point of time?
My lord, there was no validity in the registration certificate, my lord. But unfortunately, my lord.
Let us see that.
But unfortunately, my lord, the registration copy of that one, because of exchange
so you should have
of
obtained a
hands.
duplicate when you went, and how do you renew it then without a duplicate?
My lord, I can take instruction on this aspect because I was given this copy which has been renewed, but I was under instruction that even though there is not a validity period, and my lord knows well, my lord, here, once it is registered, the associations, my lord, it is valid, my lord, for good reason, for bad reason, that, my lord, it is valid, my lord.
What are the bad reasons?
But if my lord, if it is given a specific period, like now they have given in the new renewal certificate, my lord, they said valid up to 12/4/2016. Then before 12/4/2016, then I must renew, my lord. But in the earlier certificate, the original certificate, when we renewed, my lord, at that point of time, my lord, as per instruction, my lord, there was no validity period, my lord.
But you said, then how do you renew this one? On what basis did you go renew this one? You didn't have the.
My lord, there was a verifications and the due process was followed, my lord.
Let's see your constitution. Is it here?
No, they've not enclosed it.
Yeah, where's your constitution and your.
The constitutions, my lord,
and
I can.
Articles of association or whatever.
Articles of, my lord, I can produce that. It's not been annexed here, my lord.
And how was this petition admitted? When was it filed?
No, this has been filed by the power of attorney holder.
Who is the power of attorney holder?
This is.
She is one of the
Ruthila R. Mara.
Yes, she is one of the member of the clan, my lord. And
there appears to be some sort of a financial dealing, my lords, with this lady.
No, that's
if Lordships will kindly have the power of attorney, page 11 of the writ petition.
My lord, as it is, the respondent had filed an application.
Can you see clause 5 at page 11?
Oh. Where's your earlier deal agreement in 16
So
June?
this has also not been closed. We need to examine this as well.
Mr. Yobin,
my lord,
very muddy waters.
my lord, I can produce all this, my lord.
Talk about public money, that's why. That's why it's necessary that we are careful.
Lordship.
My lord, may I pray, my lord, I will bring all these documents by way of an affidavit, my lord.
You bring the original
My lord, my lord. I will take instructions, my lord. We'll try to bring it, my lord.
Stop. The petitioner has filed an affidavit on 22/5/2023, bringing on record a copy of the certificate of registration of the petitioner association, which was renewed on 13/4/2023. So, on query from the court, Mr. Yobin undertakes to produce the original copy, which he states that no renewal clause, I'm not comfortable with the original certificate of registration, as also other related documents necessary for execution of the matter. When do you want it?
My lord, 2 weeks time, my lord.
2 weeks time is granted. Yes, thereafter.
Obliged.
Obliged.
16.
May I please, Your Lordship, let this matter pass over for tomorrow, Your Lordship, as Mr. SD is supposed to do, but he went to take for his mother for check.
This matter of the 1 week due to unavailability of the respondent Archival Council.
17.
Hello. Same. 16 and 17 is.
What's the matter about appointment?
This is Lordship only with regard to the interest, Lordship. Delay payment of gratuity and leave salary.
Oh, Garvin is council.
20.
Hello.
Yes.
My lord, this case pertains to the MECL Progressive Workers Unions, my lord.
Yes.
Here, the basic grievance of the petitioners are, my lord, they have not been paid the equal wages for the employees who have been paid in the correspondent post, my lord. Now, the only criteria, my lord, is that they have been appointed, and the nature of their appointment, my lord, it's not been disputed, my lord. They have been appointed on a temporary basis or contractual basis, but this contractual basis is perpetuity, my lord, till they attain age of superannuation, my lord. And it is not that the case that they are hired on the need basis. They are there. Their contention is that we are hired on a need basis. It is not. The agreement, the contract agreement itself will show, my lord. Now, the only thing that I need to point out, my lord, is that whether this set of people are performing the same nature of job.
They're still working now.
They are still working.
But then there was some scheme that came out, they were or signed or something to be permanent. Is it in this case?
Scheme, my lord, to signing scheme.
Not scheme, some contract was re-entered.
Yes, yes, my lord. Yes, my lord. In that scheme, my lord, now there was a series of meetings between the associations and the corporations, my lord. And demand has been, and almost all the demands has been fulfilled. And we are not pressing on any of the demand because it has got. But one demand that still remains, and for which we had to come before the court, was the equal pay for the equal wages, my lord. And that has not been fulfilled, my lord. And we were
now who are the other people you think they are?
They are, my lord. Our members are made up.
They working in which grade? Grade 3, grade 4?
They are all grade 3, my lord. They are Mali, working as Mali. They're working as sweeper. They are working as cleaner.
Okay.
As chugidar, jugali.
How many are there in this union?
In this petition, my lord, the members.
Yes, come before this court.
They were, my lord, just keep secure, my lord, they was.
Anyway,
my lord. Yes.
Now I just want to know how many members are there in your Progressive Workers Union?
My lord, we have. I just forgot the exact number, but we
It's
have
hundreds or just
no, it's more than that, my lord.
More than 100.
More than 100, my lord. We are close to. I'll just give that.
It doesn't matter.
It's 600. I have the figure here, my lord. It's close to 1,000, my lord.
1,000?
1,000, my lord.
You mean, Mr. Sahai, you have that amount of contractual workers?
756, my lord.
What is the total amount of contractual workers you have who are on casual basis, and any idea with the corporation?
Lordship, offhand, I may not be able to state that number.
Here, who have authorized, my lord, to the union, the leaders to file this, they have signed, my lord, 756 members, my lord. So, my lord, kindly come to paragraph 5 of my petitions, my lord. Paragraph 5, page 5, my lord.
Yeah.
So this is, I've made a comparative chart, my lord, here. The name of the post held by the members of the union, and the second column is name of the post in regular cadre, and the third one is the nature of works.
Okay, tell me how much you have paid, how much are they paid?
My lord, kindly come to paragraph number 6, my lord. Paragraph number 6, page 7. This is also another comparative figures that we have made, my lord.
You paid daily wage and the Minimum Wages Act.
Minimum Wages Act, my lord.
Okay.
So this is the cleaner, mali, sweeper, the pay scales are this, and there was revised to the next paragraph, and the last is what we have been paid, my lord. What we have been paid.
That is 13,050.
My lord, we are paid as 345 per day into 30, that is comes to around 10,290 plus some increments and all these other things. And the minimum basic pay that the regular cadres are getting, even the minimum pay is 20,900, my lord. Now it has been revised and gone to a 47,600, my lord. That is, I'm just showing one of the paragraph, one of the chart, my lord, and so on, so forth. Jugali, palm operator, carpenter, and all these also, my lord, I've given in details, my lord. Now, my lord, only question is, my lord, now it's not a disputed fact, and it's not a disputed that we are not doing. In fact, we are also taking the same risk. For example, the lineman, my lord, the maximum number of who died, the linesmen who died, are from these people, my lord. So equal risk, equal number, equal quantity, quality of work, equal risk that we are taking also, my lord. Yet then we have been discriminated when it comes to a payment. And this is not this fight for an equal pay and equal work has been continuous for many years, my lord. And my lord, I don't want to bother, my lord, with so many representations that we have filed, my lord. Ultimately, when nothing works,
where have they rejected your prayer when you made these representations? Any reasons given for them not considering you for your prayer?
My lord, they are not considering my prayer in the sense that we are saying that we are a daily wage earner.
No, correct. I mean, have they said anything in writing that, look, you're not eligible for these reasons, or that your conditions of service and your mode of appointment is different?
Now they have taken that plea.
Now these contractual workers, they just come, means they walk in and are appointed, correct?
My lord,
what is the mode of appointment? They just walk in.
My lord, there are different modes of appointment, my lord. Here,
oh, yes.
Some of them, I must be very fair, my lord. Some of them, their words in the form of they were given because their parents were working or they are some
They
of
know
the members
somebody in
were
the
given
establishment.
sympathy, and this some of them were recruited, my lord. Also,
So you mean one form recruitment on personal consideration?
My lord,
it's not through selection.
Not through selection.
Then
My lord.
other?
So it's just this little different categories, my lord. But what matters, my lord? What matters?
No, what matters very well is where the source of where you come from. Firstly,
My
you know, to enjoy certain rights,
My lord.
you have to come from like from the same stable. Yes,
my lord.
Yes.
So, my lord, so as I said, my lord, some of them have been recruited, some of them have been selected.
Any one of them have been recruited in by a kind of a selection process?
Selection process, my lord, I'll have to then scan it out, my lord, because...
Are they have they undergone selection process, been selected and put as a casual?
As a casual, my lord, that I'll have to take instructions and try to segregate out all this. But what my contentions are here, my lord,
you're just going on the nature of duties,
my lord,
and there are
my
some
lord.
Supreme Court judgments that say that okay, fine.
Yes.
Anyway, you continue,
my lord. So, my lord, in this regard, my lord, the field that holds is Jagjit Singh's case, my lord. This reported in the year 2017 one SEC, my lord.
Yes.
And this is one of the landmark judgment, my lord, in this field, which my lords are aware. And it has discussed, this judgment has discussed almost all the relevant the cases that has been decided on this relevant subject matter, my lord. And I'd like to read, my lord, all the paragraphs which is relevant, my lord. There are around 10, 12 paragraphs, my lord. I'll start with the considerations, my lord, para 42, my lord. Yes, my lord. Para 42, my lord.
Okay.
It says, my lord, all the judgments noticed in paras 7 to 24 herein above pertain to employees engaged on regular basis who were claiming higher wages under the principle of equal pay and for equal work. The claim by such employees was premised on the ground that the duties and responsibilities rendered by them were against the same post for which higher pay scale was being allowed in other government departments, or alternatively the duties and responsibilities were the same as of the others with the different designations, but they were placed in the lower scale. Having been painstakingly taken through the parameters laid down by this court, wherein the principle of equal pay and for equal work was invoked and considered, it would be just and appropriate to delineate the parameters laid down by this court in recording the said parameters. We have also adverted to some other judgments pertaining to temporary employees, wherein also this court had the occasion to express a legal position with reference to the principles of equal pay and for equal work. Our consideration has led us to the following deductions. 42.1, my lord. The onus of proof of parity in the duties and responsibilities of the subject post with the reference post under the principle of equal pay for equal work lies on the person who claims it. He who approaches the court has to establish that the subject post occupied by him requires him to discharge equal work of equal value as a reference post. So, my lord, I've just shown paragraph 5 in my writ petition to prove the honors, my lord. And my lord, in their affidavit, counter affidavit, they have not replied to this. Means this is an admitted fact, my lord. So 42.1 in my favor, my lord. Now I'll go to 42.2, my lord. The mere fact that the subject post occupied by the claimant is in a different department vis-a-vis the reference post does not have any bearing on the determination of a claim under the principle of equal pay for equal work. Persons discharging identical duties cannot be treated differently in a matter of their pay, merely because they belong to different departments of the government. 42.3, my lord. The principle of equal pay for equal work applies to cases of unequal scales of pay based on no classification or irrational classification. For equal pay, the employees concerned with whom equation is sought should be performing work which besides being functionally equal should be of the same quantity and sensitivity. So this also, my lord, paragraph 5, just short, my lord. Then I come to 42.5, my lord, and the following page, my lord. 42.5. In determining equality of functions and responsibilities under the principle of equal pay for equal work, it is necessary to keep in mind that the duties of the two posts should be of equal sensitivity and also qualitatively similar. So, my lord, this also, then, my lord, I'll just skip the rest, may not be 43, my lord, paragraph 43. I will take my lord to paragraph 43 now. 43, my lord.
Yes.
We shall now venture to summarize the conclusions recorded by this court with reference to a claim of pay parity raised by temporary employees, differently designated as work charge, daily wage, casual, ad hoc, contractual, and like in the following paragraphs. Like in the following paragraphs, 43. We'll skip this one for a moment, my lord. This sorry, I'll skip this for a moment and we'll come to 44.4, my lord. 44.4. In daily rated casual labor case, this court held that under the principle of flowing from Article 38 clause 2 of the Constitution, the government could not deny a temporary employee at least the minimum wages being paid to an employee in the corresponding regular cadre, along with dearness allowances and additional dearness allowances, as well as all the other benefits which were being extended to casual workers. It was also held that the classification of workers as unskilled, semi-skilled, and skilled doing the same work into different categories for payment of wages at different rates was not tenable. It was also held that such an act of an employer would amount to exploitation, and further that the same would be arbitrary and discriminatory and therefore violative of Articles 14 and 16 of the Constitution. 44.5, my lord. In the state of Punjab versus Devinder Singh, this court held that the daily wagers were entitled to be placed in the minimum of the pay scale of regular employees working against the same post. The above directions was issued after accepting that the employees concerned were doing the same work as regular incumbents holding the same post by applying the principle of equal pay for equal work, my lord. Now, 46.3, my lord. 46.3, I will not read anymore, my lord, because it's all principle. 46.3. 46.3, my lord. 46.3. Having noticed the conclusion drawn in the state of Haryana versus Jasmer Singh, it would be relevant to emphasize that in the cited judgment, the employee concerned could not have been granted the benefit of the principle of equal pay for equal work because temporary daily wage employees in the said case are never ever selected through a process of open selection by a specialized selection body or agency. We would therefore be obliged to follow the larger number of cases where pay parity was granted under than the instant singular judgment recording a divergent view. Divergent view, my lord. Then another case, my lord. 54, my lord. Paragraph 54. Paragraph 54, my lord. The full bench of the High Court, while adjudicating upon the above controversy, had concluded that temporary employees were not entitled to the minimum of the regular pay scale merely for the reasons that the activities carried on by daily wagers and regular employees were similar. The full bench, however, made two exceptions. Now, there are two exceptions, my lord. Temporary employees who fell in either of the two exceptions were held entitled to the wages at the minimum of the pay scale drawn by the regular employees. So this is the point that I wanted to answer, my lord, where in what manner we had
State your claim.
Yes, no, in what manner we entered. So whether it's that will also decide the factor my lord, temporary. There are two exceptions, my lord. The exceptions recorded by the full bench of the High Court in the impugned judgment are extracted herein. Herein other, after seeing so and so. The daily wager, ad hoc or contractual appointee against the regular board, if appointed under and after undergoing a selection process based upon fairness and equality of opportunity to all eligible candidates, shall be entitled to minimum of the regular pay scale from the date of engagement. But if daily wagers, ad hoc or contractual appointees are not appointed against regular posts and the services are availed continuously with notional breaks by the government of its instrumentalities for sufficient long period of 10 years, such daily wagers, ad hoc or contractual, shall be entitled to minimum of the regular pay without any allowance on the assumptions that a work of perennial nature is available and having worked for such a long period of time. An equitable right is created in such category of persons. Now, my lord, none of the employees are below 3 years, my lord. They have all been, some of them are at the verge of retirement also, my lord.
Yeah.
Their claim for regularization, if any, have to be considered separately in terms of legality permissible. In the event, my lord, after discussion all these cases, my lord, then the court came to a conclusions, my lord, at 61 in view of the position expressed by us in the foregoing paragraph. We have no hesitation in holding that all the temporary employees concerned in the present bunch of cases would be entitled to draw wages at the minimum of the pay scale extended to regular employees holding the same post, my lord. Now, my lord, kindly look at the some of the minutes of the meeting that was held between the corporation and also with the members, my lord. Page 180, my lord.
1 second.
Page 180, my lord.
180 of your
180, my lord. Of my read petition, my lord. That is annexure 7, my lord. Here, my lord, I must just come back to the first and describe ourselves, my lord. We are long-standing casual workers, my lord. That will be appropriate to describe us, my lord.
Yes.
My lord,
what do you want to show from
paragraph
this meeting?
2, my lord. Paragraph 2.
Okay.
Paragraph 2, where the minutes of the meeting. As long-standing casual, my lord has got a point.
1 second. Yes.
As long-standing casual workers, we have been doing work for regular nature. We also request you to begin the due process of regularization of our work. The Director of Corporate Affairs MECL informed that regularization of so paragraph 2 will skip. This one is for the regularization. We are not pressing now. Paragraph 3, my lord. Paragraph 3, as the nature and feature of our job remains the same as those of regular workers, while we demand and await regularization through due process, we request immediate implementation of the Supreme Court order of equal pay for the equal work, civil appeal number so and so. While referring to the demand for equal pay for equal work, the Director of Corporate Affairs, the MECL, informed that certain following criteria has to be fulfilled to be implemented a union: the nature of work and responsibility, educational criteria, they should have been appointed through regular process of law, they should be working against sanctioned post. However, the above will be taken up in the management for consideration and order. So this was the minutes of the meeting. Now, my lord, So the rest, and again, my lord, we have written many 184. These are the again 184. These are again minutes of the meeting, the following minutes of the meeting, and so on and so forth. Now finally, my lord, finally it comes to 191. 191. This is sample contract agreement that we have signed, my lord.
What contract you signed? That's what the school also see. Very important, but yes.
Yes. This is the contract
of personal service.
Yes, my lord. Contract of the person's service, my lord.
Yeah, it is written here.
No, there's a contract agreement. There's a contract agreement.
Yes. So what is this? Does it prescribe the rate you're going to be paid?
This
Where
is.
does it say? It's just a draft. It's just a.
This is a.
But did all of you sign it?
My lord, kindly look at this.
Clause 5 at 192, Lordship, on the issue of wages.
We have a sample which has been signed. We have sample.
Sample that has been signed is there, my lord. It's this sample has come because of the minutes of the meeting of 194 page. The sample that has been signed, my lord, is at it's at page. It's page 198, my lord. Page 198. Now 199, my lord, the paragraph 199, my lord. The party of the first party shall submit himself or herself to the orders of the so and so authority and officers and authorities, and from time to time place under automatic, and shall remain in service for 1 year connecting from and subject to automatic annual renewal of contract unless there is a negative assessment on the performance of the contract workers, which shall be based on the management on the report of the controlling authority, for which 1 month notice shall be given to the party. The party shall so and so it goes, my lord.
So that's not shown. That part not shown. This is remuneration attached to the post.
My lord, the remuneration attached to the post.
6,600.
Yes.
From time to time.
The remuneration attached to the post, which the party of the first part is appointed, shall be a monthly rate of rupees 66,000 or 6,600, 6,000, to be revised from time to time as per so and so.
Okay.
Yes. Second corporation. Well, this part. In this part, my lord, I'm little bit. I need to take instructions. Little part, my lord, is towards the part, my lord.
See, we are coming into the area of
Yes.
our contract of personal service also.
My lord.
Vis-a-vis, like just it's not on block like temporary workers.
My lord, this area, my lord.
Mr. Sai, what do you have to say? Yes. Mr. Yubin is taking a time out. He says he wants it another time. Yes.
On first principles, Lordship, I'll just address the court on first principle. Equal pay for equal work, a claim for equal pay for equal work is essentially a claim of Article 14. It is that if the person should not be arbitrarily discriminated against a similarly placed person. So essentially the touchstone of assessing whether or not such discrimination is being meted out is through Article 14. Now, if the employer demonstrates that there is a reasonable classification and a nexus that exists in paying a different salary to a certain class of employees as against the regularly employed persons, then the court would be reluctant in interfering and putting down a direction of equal pay for equal work. That is what has been held in various judgments. That is precisely why the evaluation criteria are: number one, whether the educational qualifications are the same or not; number two, whether the source of employment is the same or not; number three, whether the nature of duties are identical in the absolute sense and require the same degree of skill between the same class of employees. So there are various categories that the courts have time and again reiterated, and that is why a mechanical application of equal pay for equal work is not in fact carried out, or not. In fact, it has been deprecated. That claim itself has been deprecated. That simply because the post that is being held is having similar duties, that by itself will not be sufficient. The court must evaluate what is behind that post, in that the recruitment process must be same, etc., etc. So in that light, Lordship, as has been considered, in fact, that here is a case where other than the duties being discharged by the persons being same, nothing in fact is same. They are ranked temporary employees. There is nothing in the writ petition that demonstrates that the recruitment has been done after following the same rigors as would be against a sanctioned post. There is nothing on the writ petition to indicate that the educational qualifications held by these employees are the same as those who are regularly recruited. There is nothing, in fact, on record other than the ipse dixit of the Petitioner Association that there are, in fact, identical duties being discharged with identical amount of skill and expertise. So therefore, with these things in mind, Lordship, on the first principles alone, my respectful submission is that there is sufficient difference between the persons holding regular post and the persons who are temporarily employed.
So what is the impact of the contract signed individually with these people?
Lordship, the contract of course cannot be contrary to law. So if the basic under law their entitlement would exist, then that could not be wished away by a contract. So the employer, particularly state, could not say take shelter of the contract and say that
if the contract meets the minimum requirements of that they pay the minimum wages and so on and so forth, what would be the effect of the contract on is the contract a personal service of each person? Correct. So
yes. So therefore, Lordship, in fact, that would be enforceable as against these employees. That would be an enforceable contract which they have bound themselves to at the time.
But that will not be a bar for them to claim equal pay for equal work.
If they were otherwise
will it operate as a bar?
In my respectful submission, in the present case, it would, because this contract demonstrates the fundamental difference between a regularly employed person and a temporarily employed person.
Okay.
A regularly recruited person will have no such
valid
contract.
Point, yes.
It would not have such a contract at all. They would go through a recruitment process and they would be recruited full-time and against a sanctioned post. But here is a case where there are in fact contractual aspects of the employment which are evidenced by this contract. So, and none of the portions of this contract have been, there is no declaration sought that this contract is unconscionable. There is no declaration sought that this contract is unenforceable.
There are no pleadings at all with regard to that disregarding there's nothing.
Absolutely. And that
so you
is why
any pleadings with regard to the contract?
My lord, with regard to the contract, my lord, page. This, my lord, after signing this also, my lord, in what manner?
No. Have been the pleadings
pleadings,
what you're submitting right now, you say the contract will not be a bar to seeking other reliefs, which are under Article 14 with regard to nature of duties. Anyway, you want time out? Let him take a time out to prepare.
Lordship, I have no difficulty.
Para 8, my lord, just very quickly answer, my lord. In para 8, what did I say is that the petition humbly states that pursuant to the charter of demand, several meetings have been taken place between the petitioner and the respondents. The first meeting was held on 07 December 2017, in which the meeting at agenda number 3, the implementation of equal pay for equal work in terms of was discussed. The second meeting was held on so and so. At agenda number 9, the issue pertaining to equal pay was discussed. The third meeting was held on 2020, in which the meeting issue equal pay for equal work was held. Again raised the petitioner, but surprising, it was not included in the minutes of the meeting. Not included in the minutes of the meeting.
No, I'm talking about the contract specifically.
My lord, then I'll just come back with this contract. Let it be part heard, my lord. I'll come back with the.
No, because it came part heard. This is 19 matter.
This is a 19 matter.
Mr. P. Oben, in the course of the hearing, Mr. P. Oben seeks time to further. What do you call it? You're taking time for what? To further prepare the matter. See, you have to meet this point, like the basic fundamentals with regard to equal pay for equal work. It's not so simple as, carte blanche like that, that the nature of duties. There are the decisions also.
My lord.
Which are in your favor and which against you.
Against you, me, yes.
Yes. Yes, so yes.
25.
After 2 weeks.
Please, Your Lordship.
Where's you produce appointment order?
Your Lordship, I may be allowed to file an additional affidavit to bring on record the appointment order.
And it says record of each petitioner's come for this court. This regarding to same one.
My lord, the agro custom, the microfed agro custom, my lord.
Very weak case you have. Tough case, but not weak case. Every case is good. Remember, when a case comes to a lawyer, every case is good. It's a good case. Never see it as a bad case. You fight out. Maybe your name is
in Marak, Your Lordship.
Dear Marak, yes. Everything Marak, Learned Counsel for the petitioner. Please be allowed to file an additional affidavit to bring record the appointment orders and specific service records of each petitioner who has come for this court. Prayers allowed. 2 weeks time is granted.
26?
Yes, the last one.
26 and 27 is a similar matter, Your Lordship. Similar prayer, Your Lordship.
28?
Yeah, please, Your Lordship. In this matter, we would like to withdraw and with liberty to file afresh, as there's some development we'd like to bring on record.
As some of the instructions may be permitted to withdraw this instant application, however, liberty to file afresh is so advised.
Just filed a Vakalatnama yesterday, Your Lordship.
Yes?
We had just filed a Vakalatnama yesterday, Your Lordship, in this matter.
Okay. Ms. Raspana, who's newly, Ms. Esmal Pana, who has been newly engaged in the instant matter, submits that due to certain developments in the case, he may be allowed to withdraw the same. However, with liberty to file afresh if so advised. So next, accordingly, matter stands posed on withdrawal. However, liberty as prayed.
29?
Lordship, this is the new pension scheme, old pension scheme issue. On the last occasion, in the midst of this.
Where's your opponent? New pension scheme.
May I please, Your Lordship? Mr. Senator.
Yes.
On the last occasion, during the midst of the hearing, Government Council was asked to produce some records, as queried by the court.
My Lord, I have not obtained any fresh documents. These are the same documents which has been shown to me earlier, has been the ones we will be relying on, my Lord. No fresh or additional.
What you said that